Everyone. I'm Len Garza. I'm the managing attorney at Garza Business Law and Estate Planning. For almost 15 years, I've been helping business owners and their families in New York, New Jersey, Pennsylvania develop comprehensive business and estate plans and help them set up their business for success. I'm here today with Natalia Ouellette from LCO Law LLC. Natalia is a Florida real estate and estate planning attorney, and she spent over a decade helping real estate investors plan today for a legacy of wealth tomorrow. Natalia, welcome.
Hi, thank you, Len. Happy to be here.
Thanks. So today we'll be discussing a Q&A session about Florida and real estate closings and Florida ancillary estates, because it's incredibly popular for families living in the tri-state area to buy a second home in the Sunshine State eventually before they retire. So it's really important for my clients and members of the tri-state area community to understand the process of buying real estate in Florida and what happens if you pass away owning real estate in the Sunshine State.
That's right, Len. And it's so incredibly common that it's actually my story. My family lived in New Jersey for decades, and as the time came for them to retire, they slowly transitioned their way here to Florida. There's still a few of them left in New Jersey, but that's kind of the reason why it's so important. It's so common, and how can you say no to like vistas of what I have in my background of the Tampa Bay area? You just can't.
Right.
So without further ado, let's get to the meat and bones of, what is involved in buying real estate in Florida, and what's involved in probating something if you pass away with assets in Florida. So go ahead, Len, fire away.
It sounds good, Natalia. And hey, who wouldn't like that in your background? That Tampa looks like it's got a lot going on. Who wouldn't want to move there, right? So people who are thinking of Florida definitely are thinking in the right way. So let's start off, Natalia, by talking real estate in Florida. Let's say I'm someone in the tri-state area. You see this situation come up a lot, at least I do, and they're looking to buy in Florida. Let's say an investment property. They're thinking about it. However, they have no idea about the Florida real estate market. They may have likely have vacationed in Florida, but as far as looking into real estate, actually buying in Florida, they don't have any prior experience. They don't know where to turn. Can you give us an idea what's involved in the Florida real estate closing process?
Sure. So first step, obviously, you're going to be looking for the property, and there's a lot of different places where people start. Obviously, you've got the realtor.com, Zillow, those kinds of places where they just become familiar with what property looks like here, the prices, etc. From there, people generally connect with realtors. And if you are out of state, I absolutely recommend that you shop around, talk to different realtors, get a feel for their experience, all of that, because they might say, yeah, sure, like I'm super familiar with property in Orlando, but they might actually only do deals in St. Petersburg. So it's important for them to know the region. When it comes to the contracts, closings are a little bit different here in Florida. And people from New England are very familiar with law firms handling everything from beginning to end, and that's actually not as commonplace here. Here, title companies are the ones that handle the majority of the transactions, and very few title companies actually have attorneys handle the closings. What we have here is title agents who are licensed to do limited legal type of work under the auspices of underwriters that issue title agent licenses to them. And they prepare all of the transactions. They prepare the closing statements, they prepare the deeds, they act in accordance with the contract to hold in the money and distribute the funds to all the parties. And so it's really important to not only in selecting a realtor, select somebody with familiarity, but selecting somebody that has a really good relationship with a Florida title company, and a Florida title company that is very familiar with handling closings that are going to be done through mailings, because obviously the last thing you want to be forced to do is travel to Florida if you don't want to. Granted, we have lovely beaches, but if you don't have to, you don't want to have to do that. So that's kind of how the process goes here.
Absolutely, Natalia. And you bring up something that's so important. It's so key to deal with professionals, title companies, attorneys, realtors that are familiar with that area, that process. Because I see it here in New Jersey. North Jersey closings are different than South Jersey closings, or different than Pennsylvania closings, or different than New York City closings. So Florida definitely has its own specifics. So thank you for giving an overview of that information. So we talked about some of the different roles. What role does an attorney play in a real estate closing for an out-of-state buyer for Florida real estate?
So when you are, acquiring property, you are making one of the biggest investments of your life. That for people generally, real estate is the biggest thing they own, whether it's a piece of $3 million property or $150,000 property. It's a substantial amount of money for anybody. So here, people have the ability, they don't have the requirement, but they have the ability to hire counsel to review those documents for them, to review the contract before they execute it. I mean, Florida real estate contracts are very different than contracts from any other state. Real estate law is so state specific that it really matters that if you want to know what you're getting into, you have somebody that's trained in it, explain to you, like, here's the nuance, here's what would happen to have you lose your deposit, here's how much time you have to inspect the property, here's the kind of recourse in terms of, like, are you going to be forced to mediate first? Are you going to be forced to arbitrate first? Those are all really important things because they're costs that can balloon to levels that you wouldn't imagine if you are not understanding what you're getting into. So title attorneys, such as myself, for example, would review those closing documents prior to you executing contracts or throughout the process, reviewing the legal descriptions, making sure that the title commitment the title company creates didn't miss anything when they examined the chain. They didn't miss a mortgage. They didn't miss prior owners that need to execute documents, that everything is proper and in its place, and that those closing statements really do reflect the numbers that you've agreed to with your seller or your buyer if you're doing that kind of an exchange here in Florida. So they play a very good substantial role, and they can also sit with you at the closing and explain the closing documents for you if you don't want the title agent to do that.
Wow, that's a lot there, Natalia, that a Florida attorney can help out with. And I guess even though a Florida attorney wouldn't strictly be required by law to handle the closing, hiring one to just explain all the pitfalls of potential terms and conditions would really be of great benefit there, especially if you're unfamiliar with real estate in Florida. So let's switch gears slightly. Ancillary administration. Let's talk about what happens when, let's say further down the line, a New Jersey or tri-state area buyer has bought Florida real estate, owns real estate, and now they pass away. If I'm that buyer and if I've passed away, I have property in my current state, New Jersey, New York, Pennsylvania, and Florida at the time of my death, what happens then? Where will my estate be administered?
So that depends largely on whether you had documents written up as a part of your estate plan or if you died intestate. If you passed away intestate, then generally the process is somebody has to be appointed as personal representative in your primary state where you resided. So New Jersey, for example, and they have to comply with, whatever the New Jersey requirements are for qualifying to be a personal representative. That personal representative, once appointed in New Jersey, would then have to get approved as a personal representative here through what qualifies them to be a personal representative in the state of Florida. If they're not closely related by consanguinity, meaning like they're either not spouse or the children or maybe the siblings of the person that passed away, then they have to be a Florida resident. So that can get tricky because what if you don't know anybody that you trust in Florida? Like, who's going to handle that for you? If your children don't have the ability to travel, if your wife, for example, or your husband is incapacitated and can't do that kind of travel to come to Florida. So it really puts a dent on the process or slows down the process if you don't have an estate plan in place. On the other hand, if you have an estate plan, even if it's a New Jersey estate plan where you've designated a personal representative, that personal representative, that will is going to be, so long as it's approved in the New Jersey courts through the New Jersey probate administration process, certified copies of those appointments get accepted into the Florida courts a lot faster. And so you could have the same personal representative. The only thing that would disqualify them would be if they were somehow a minor, or if they were, for example, a person that had been convicted of a felony, because in those cases, you're not qualified in Florida. But for the most part, they will respect whatever your estate planning document said as far as appointment goes, so long as it was a general appointment over all the properties. Some people sometimes put in their will, you know, for my Florida assets, I want this personal rep, and for my New Jersey assets, I want this personal rep, but that's not necessary. So long as it's comprehensive in your New Jersey estate plan, you can have that person be the PR here. And so it's a process where you have your personal representative send over certified copies of the paperwork, the letters appointing them as PR in New Jersey, a certified copy of the will. That's obviously the original is going to be left in New Jersey. Certified copies of the death certificate. That all gets put into the ancillary courts here, and it's a much faster process if you've got an estate plan in place. Much faster.
Wow, well, that's a lot of great information to chew on, Natalia. Thank you so much for giving that overview. There's a lot to think about for tri-state area clients and people looking to buying property in the Sunshine State. Thank you for giving us that overview, Natalia.